slaves and hit those buttons, or I'll send ice.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape paint. We ain't talking vapes or the color of drapes, or a gorilla in a cape. It's the good shit, just one hit. You so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castrations, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dog said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you tonight with some more on the current constructive eviction now. And if you're familiar with what's been going on so far over my probably 6 or 7 videos here recently, you'll see a certain outline that I presented. And so we're going to take a look at Proverbs 28:8-15 to show you a foundational element that coincides with what's going on in this case. And it starts out, he that by usury and unjust gain increaseth his substance, he shall gather it for him that will pity the poor. He that turneth away his ear from hearing the law, even his prayer shall be abomination. In other words, when he goes to the court seeking prayer of remedy in a wrongful eviction, it shall be an abomination. She's the one that admitted on the record that she didn't follow the law. Whoso causeth the righteous to go astray in an evil way, he shall fall himself into his own pit, but the upright shall have good things in possession. This is why I say when people run around lying about things, they're the ones that are laying their rope that's going to hang them. They're using bitter words against people and putting them in bad lights and casting character faults on them as if though they're true and correct, and they're not. If they're built on a foundation of bearing false witness, then they will get caught up in their own lies. They'll get strangled up with that rope they lay. The rich man is wise in his own conceit. That's it, nothing else. But the poor that hath understanding searcheth him out. And it's talking about the wisdom there. When righteous men do rejoice, there is great glory. But when the wicked rise, a man is hidden. And that's what we're stating here, is that when the administrative process is overbearing the truth in the record and trying to hide it. It's a silence of that righteousness. He that covereth his sins shall not prosper. So the property manager who went in and admitted under oath that she violated strict statutory duties, that was in fact a rights violation. They're not supposed to prosper, but yet here she entered in a voluntary dismissal despite that fact. But whoso confesseth and forsaketh them shall have mercy. So I've been opportunistic for them all along. I've been giving them all fair warnings of their duties and obligations, and they're all denying them. Somewhere along the line, I hope we find somebody that is just. Happy is the man that feareth always, but he that hardeneth his heart shall fall into mischief. As a roaring lion and a raging bear, so is a wicked ruler over the people. So which one of the people that we're going to will stop acting in a wicked way by hiding the truth and not doing their strict statutory duty under misprision of felony, bearing false witness, that mutilation or alteration, or tampering with the witness, victim, or informant. So that's the basis of our whole entire claim. And it comes from the spiritual principles, again, founded in Matthew 18, verses 15 through 20, where we went to our neighbor in private first. And when they didn't hear us, we went to the property manager. They didn't hear us. And then they turned around and took us into the public venue where we're operating and conducting our affairs as witnesses, two witnesses coming forth with truth and righteousness and trying to let them know they're the ones violating the law. We're conducting everything in good faith. We come with clean hands and the truth in everything. So let's take a look. I got to drop this one. Okay, let's see here. Okay. So this here is a formal complaint of housing discrimination. So along with all of our filings, we're now going to give a formal complaint of housing discrimination to Housing and Urban Development, HUD. Office of Fair Housing and Equal Opportunity. This is because there's a Fair Housing Act violation in refusing to have a interactive process in regards to the request for reasonable accommodations. From Keith Little and Joy Schmidt, the address, respondent, property management, basis of discrimination. We are filing this complaint based on disability and retaliation under the Fair Housing Act, 42 U.S.C. 3604 and 3617. We discussed them in a previous video. Statement of facts. Protected Act. On December 16th, we made a noise complaint to the property manager due to excessive noise from the upstairs tenant. Then January 5th, 2026, we made a formal request for a reasonable accommodation for Joyce's disability after receiving a 3-day notice of eviction under clear and present danger statutes. Adverse action. In direct response to our noise complaint and request, the respondent filed a clear and present danger eviction action, Blackhawk County case number, and then the case number, without the 7-day statutory notice upon our original noise complaint on December 16th, 2025. This notice is required by Iowa Code 5628.27. Judicial admission. During the trial held on January 26, 2026, the respondent judicially admitted under oath to the lack of proper notice and the ignorance of not knowing the respondent has a strict statutory duty to do so. Interference with rights. Following this confession, the local court has engaged in an administrative shuffle involving 5 different judicial officers to allow the respondent to voluntarily dismiss the case post-trial. This is despite the court's strict statutory duty, and I have to amend this. 4 different judicial officers to allow the respondent to voluntarily dismiss the case post-trial. This is despite the court's strict statutory duty to hand down the finding of presumption of retaliation. Heather Feldkamp took the case under advisement as a result of conclusive evidence of substantive rights violations in the respondent's confession. This is a bad faith effort to suppress the record of the respondent's confession and to interfere with our federally protected rights. Relief sought. We are requesting that HUD initiate a formal investigation into the respondent's retaliatory filing and the subsequent interference with the administration of our fair housing rights. We seek a finding of probable cause for retaliation, injunctive relief to prevent further retaliatory eviction attempts. So it's not just, it's a class of 1, but it's as a relief to prevent further retaliatory eviction attempts across the board by finding this probable cause of retaliation. That's a summary judgment already. Once they admit it on the court, it's already a summary judgment. It is conclusive. No way around it. They cannot, it's an immutable record. They cannot mute the record. Damages for emotional distress and costs incurred due to this bad faith litigation. We've already given notice of intent to file a claim. Declaration, we declare under penalty of perjury that the foregoing is true and correct to the best of our knowledge. The next one, let me double check here. Greetings, everybody. Go ahead and hit that like, share, and subscribe button. Hopefully you can help with the PayPal link. It's pinned at the top of the comments. All is helpful. And in the meantime, let's get back to this. The next is the formal complaint under Iowa Code Chapter 216 to the Iowa Office of Civil Rights. Housing intake from Keith Little and Joy Schmidt, respondent, basis of discrimination. Pursuant to Iowa Code 216.8a, housing discrimination, and 216.11, retaliation, aiding, and abetting. The basis for this complaint are disability and retaliation. Statement of allegations. Request for accommodation on or about January 5th, 2016. We exercised our rights under the Iowa Civil Rights Act by requesting a reasonable accommodation for Joyce's disability. Retaliatory eviction. Within days of this request, the respondent initiated an eviction action characterized as a clear and present danger, despite failing strict statutory duty of 7-day notice to cure upon our original noise complaint on December 16th, 2025. Judicial admission of statutory breach during the trial on January 26, 2026. The respondent admitted under oath to failing to provide the mandatory 7-day notice required by Iowa Code 562A.27 and further admitted to facts establishing the retaliatory nature of the filing. Further admitted to facts establishing the retaliatory nature of the filing is that she admitted that she knew of an ongoing situation. She knew it extended from our original complaint about a noise issue, an excessive noise issue above, and yet failed to do anything about it at that point. Aiding and abetting interference. Since the respondent's admission, the local court has engaged in an administrative shuffle to allow an unauthorized post-trial dismissal. This administrative action serves to aid and abet the respondent in avoiding the legal consequences of their confessed discrimination in violation of Iowa Code 216.11. Brief summary of harm. The respondent's actions have caused significant emotional distress, housing instability, and financial burden. The attempt by the judicial system to suppress the record of the respondent's confession further exacerbates this injury and denies us the right to a remedy guaranteed by the Iowa Constitution. This is that right to cure. That's the entire purpose of the 7-day notice to cure. You have a right to cure things first and remedy the situation yourself. In other words, when I complained to the upstairs neighbor, they could have remedied it themselves. When I had to go to a second person, the property manager, and complain about it, they were supposed to give them a 7-day notice to cure, giving them also a chance to fix it. They did not do so. That's their bad faith. not mine. Oath and signature. We, Keith Little and Joy Schmidt, being first duly sworn, state that we are the complainants herein, that we have read the foregoing complaint and know the contents thereof, and that the same is true and correct to the best of our knowledge and belief. Da, 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 da. The next one. And this is what I call a shotgun blast. Like I said, I noticed HUD and IOCR. And now we're going to address the Institute for Justice. I've already addressed the Iowa License Commission in regards to their real estate license and all that. I got some word back from them. And what I can do is, once this is finalized and show evidence through transcripts and everything that they admitted all this stuff, I can reissue my complaint. And they can now, even if they are licensed, even if they were properly licensed, it absolutely shows that they had a strict statutory duty by license. So then they can actually uphold them to it. So that's what we're looking at there. And then to continue on, this is attention Anya Bidwell, Senior Attorney, Project on Immunity and Accountability. Or attention Anthony Sanders, Director, Center for Judicial Engagement. Structural obstruction of justice and systematic denial of remedy, Iowa 1st District. The constitutional challenge. This case presents a grave instance of structural obstruction of justice where the Iowa 1st Judicial District utilized administrative shuffling to bypass a recorded confession and a mandatory presumption of retaliation, Iowa Code 5628.36. And this conduct represents a targeted denial of the right to a remedy and a total failure of judicial accountability. Judicial admission of federal and state violations. During a forcible entry and detainer trial on January 26, the plaintiff, property manager, judicially confessed under oath to a series of Fair Housing Act and IROLTA violations. These admissions included selective enforcement, intentionally refusing to serve a 7-day notice to cure on an offending third party after a noise complaint, December 16th, while weaponizing the court against the complainant. Retaliatory action, admitting to filing the eviction in direct response to a disability accommodation request. Judicial breach, admitting to bypassing the mandatory 7-day notice to cure, and that's 5628.27, before filing the FED action, showing that they came to court with dirty hands. Iowa law, Iowa Civil Rights Act, under Iowa Code 216.8a, the Iowa Office of Civil Rights follows the federal interactive process standard. In the case of Cohen versus Clark 2020, the Iowa Supreme Court highlighted that landlords must balance the needs of multiple tenants. They must engage in a fact-specific inquiry dialogue rather than an automatic denial. In other words, they're supposed to specifically communicate with us as the disabled tenants to find out what we could find or bring as a remedy. Move them from an upstairs apartment to another downstairs apartment somewhere where they're not running, jumping, stomping, yelling, hollering, screaming all day. Would have been fair to me. The magistrate shuffle and the clerk's interference. Upon hearing these confessions, the court was statutorily mandated to enter a finding of retaliation. Instead, the court initiated magistrate shuffle. This is an administrative diversion. The case was moved through 4 judicial officers to avoid entering a final judgment on the merits. Unauthorized dismissal came from Magistrate Cooley, who facilitated a voluntary dismissal after the trial concluded, in violation of Iowa Rule of Civil Procedure 1.943, effectively dismissing the plaintiff's recorded confession. 14th Amendment violation, and this is why I warned the clerks of their duty. Clerk's false entry. The record was further manipulated by an unauthorized entry of court costs against the defendant. This constitutes a false entry that violates the 14th Amendment's due process clause and defies the Iowa Supreme Court's mandate in State versus Paglia, January 26, 2026. And it doesn't matter if a judge gives you an order or not. You have the obligation to follow the laws of the United States, the Constitution, and such. And in not so doing, that's on you. Ignorance of the law is no excuse for you either. Conclusion, seeking accountability, the defendant is currently securing 45 pages of certified trial transcripts as evidence of this structural evasion. We seek the Institute for Justice's assistance in challenging this class of one treatment where the judiciary has actively shielded a civil rights violator from the legal consequences of their own testimony. We're not stating anything false, folks. We're not stating anything false. The next one, in the Iowa District Court for Blackhawk County, when we get these transcripts, as soon as we get these transcripts, notice of filing of certified transcripts as conclusive evidence of judicial admissions and threefold statutory breach. Comes now the defendant's pro se and formally files the certified transcripts of the January 26, 2026 trial. These transcripts are submitted as conclusive evidence of the plaintiff's judicial admissions regarding a systemic failure of statutory notice, establishing a prima facie case of retaliation and a jurisdictional defect that the court is mandated to recognize. Transcript as the irrevocable record of the triple failure. Defendants presents these transcripts to ensure that the sworn testimony of January 2026 remains an immutable part of the record. The transcripts record the property manager's judicial admission to a threefold breach of the strict statutory duty found in Iowa Code 562A.271. The first failure, December 16, 2025, plaintiff admitted to receiving a good faith noise complaint and intentionally refusing to serve the mandatory 7-day notice to cure upon the offending upstairs tenant, breaching the defendant's right to quiet enjoyment at section 562A.15. Second failure, January 2026, plaintiff denied a request for reasonable accommodation of an interactive process. This was January 5th. This process is a mandatory good faith dialogue between the housing provider and the tenant to find a solution that works. Instead, the plaintiff immediately escalated to a retaliatory eviction, filing without any intermediate statutory notice. Third failure, January 26, 2026, the entrance of this case shows the property failed to give, or the property manager failed to give a 7-day notice to cure prior to the filing of the forcible entry and detainer. The case was entered under a 3-day notice of eviction. The plaintiff admitted that they did not know they had such a statutory duty to give said 7-day notice to cure, and has also shown complete disregard for the mandatory duty of interactive process, a protection under the Fair Housing Act. Under Iowa Code 216.AA, the Iowa office, we read that one to you earlier, and the doctrine of dirty hands and jurisdictional nullity. A party seeking equity must do equity. The transcripts prove the plaintiff invoked the court's jurisdiction with dirty hands. By confessing to the triple failure of notice, the plaintiff admitted that the court lacked the legal authority to hear the case from its inception. A forcible entry and detainer action brought without the jurisdictional prerequisite of a 7-day notice is a legal nullity. This is not a question. It is a Rule 12B, failure to state a claim upon which relief can be had. Mandatory duty to apply the presumption of retaliation. The transcripts document the factual foundation that triggered the mandatory presumption of retaliation under Iowa Code 562A.362. Once the plaintiff admitted to filing this action within weeks of a disability accommodation request and admitting to skipping all mandatory notices, the magistrate had a mandatory duty to shift the burden of proof to the plaintiff. That's not a question any longer of either party. It's the magistrate. The magistrate had a mandatory duty to shift the burden of proof to the plaintiff. This is Magistrate Heather Feldkamp. The magistrate's shuffle witnessed thereafter was an unauthorized attempt to bypass this duty by Heather Feldkamp through administrative avoidance. Preservation for federal and state civil rights review. Pursuant to Iowa Rule of Evidence 5.902, these transcripts are self-authenticating. They serve as an unimpeachable record for HUD and the Iowa Office of Civil Rights, documenting a confessed violation of the Fair Housing Act. The voluntary dismissal finalized by Judge Rattenborg cannot vacate the truth of the plaintiff's sworn testimony. This transcript is filed to ensure that the structural obstruction of justice witness in this district is exposed and that the plaintiff is held accountable for their confessed interference with the state and federally protected rights. Conclusion: the defendant requests that the court, the chief judge, and all reviewing administrative bodies take judicial notice of these transcripts. The plaintiff's own words have nullified their claim and established a record of retaliation that no administrative shuffle can erase. Supplemental notice. The defendant is presenting the official trial transcripts of January 26, 2026 as conclusive evidence of the plaintiff's confession of statutory federal violations. While the court has attempted to administratively finalize this matter through an unauthorized dismissal, the court cannot vacate the sworn testimony contained within this record. These transcripts establish that the plaintiff lacked jurisdiction from the inception of the filing due to a failure of strict statutory notice, and that the court failed its mandatory duty to apply the presumption of retaliation. This record is being preserved and presented for review by federal and state oversight agencies to ensure transparency and accountability for the structural obstruction of justice witnessed in this district. The transcript as permanent evidence. The transcript as the record of confession, regardless of whether the district court refuses to judge on the merits. The transcript of the January 26 trial functions as a judicial admission. It functions as a judicial admission. It is an accounting. It is an accounting of the events, and therefore it is an account. Self-authenticating evidence under Iowa Rule of Evidence 5.902. A certified transcript is self-authenticating. A permanent record argument. You are presenting these transcripts to ensure, We are presenting these transcripts to ensure that the 18 U.S.C. 1512 tampering, withholding, and 1519 falsification arguments are backed by physical proof. If the court shuffles the case to avoid seeing the confession, the transcript proves exactly what they are trying to hide. Defeating the mootness argument. The court may claim and has claimed the case is moot because it was dismissed. That's exactly what they did. They did so at the cost of the defendant, which is a violation of Iowa state law, which we showed in the previous video and referred to here in State versus Paglia, January 9th, 2026, here in Iowa's Supreme Court ruled that is a violation of state law. The counter argument, a civil rights violation is never moot. The transcript provides the factual basis for a collateral estoppel claim. This means the landlord cannot deny in future civil rights lawsuit what they already admitted to in an eviction trial. No matter what the outcome of this trial, no matter what the court wants to do with it, I can still now go forth with the civil rights claim. They already admitted on a record that cannot be suppressed. And that is because the public interest exception in Iowa, even if the case is technically over, the court can rule on if it involves an issue of great public importance that is likely to recur. This lady admitted to doing this for 8 years and did not know her strict statutory duty to give that said 7-day notice to cure. So I imagine there have been many people that have been evicted unlawfully because she simply did not know. Forgive her for she did not know, but we must re-educate her, retrain her, do whatever is needed to prevent it from happening to others, the greater public interest. Not just me alone, but everybody else out there, like me expressing it and your right to know. Both the plaintiff admitting she has been managing property for 8 years and the magistrate's scuffle is exactly that. The force of the transcript in administrative claims, the transcript acts as the superior evidence. It bypasses the he said, she said phase of an investigation. It's already admitted on the record. Retaliation is presumed, and she has no way out of it now. It proves the landlord had dirty hands the moment they stepped into court. It proves the magistrate had a mandatory duty to act on the presumption of retaliation, but chose administrative avoidance instead. And understand, folks, I've given them notice of everything along the way. Everything along the way. Let's see. Man in traffic court some days ago get FTA warrant put out, and he was there. Special appearance as authorized rep for defendant mentioned something like mistaken ID and wish to clear the matter. Yeah, it's getting into a lot of language there. That may be so on an underlying level, but we have to understand the grammar put before us, and when we can restrict ourselves to the syntax of how they understand it, and that's going to be the basis. So, and this is why I do these simple writings like this. This is in a simple structure that they can understand it. It's according to their own rules. They're the ones that are subject to those rules and are violating them. And each time they violate them, that's a civil rights violation against both of us. And I can make a claim on each and every one of those. So I say we can actually up it and start asking for more than 250,000. These violations keep stacking up like this. It's amazing. I don't carry a state ID. I don't identify myself as that entity. I make a clear distinction. I know the difference between the person and the personage and the noun phrase structures versus nouns, as in God formed man of the dust of the ground, and when he breathed the breath of life into it, man became a living soul. So we have a noun versus a noun phrase. This is where there was a stationary noun. Man is a stationary noun. It's a personification, literally in a descriptor. And then living soul is the noun in action. That's why it's called a noun phrase. It's a noun in action. It's not stationary. It's an in action, and therefore more of a verb style descriptor. It's telling you something real as opposed to something fiction. So anyway, that's what's going on so far. We're going to start giving out more notices. Like I said, the HUD is going to get a complaint in regards to the FHA, Fair Housing Act, and other things, as we read. And then, of course, the Iowa Office of Civil Rights, they're going to get a notice. And then we're also going to do a notice to the Institute for Justice. Oops. What do we do here? So yeah, I'll be bringing more when it comes to this stuff, guys. Feel free to hit the like, share, and subscribe button. There's a PayPal link pinned for anybody who wants to share some love. Every little bit is going to help. I'll appreciate it. And in the meantime, remember, most things have already been paid for when it comes to these debts of sin.
accounted for. My name's been read, written in the ledger where the lamb was led. Did not the body, did not the blood pay every debt in the flood of love? So tell me now, what's left to owe? When mercy calls, I can't say no. Are we too old? No man anything. Just grace erase what the law might bring. If love's the all, then love fulfills all that binds all their wills. Silver spend, the temples fall, but the heart still whispers through it all. Render to God what is divine, and what remains is only mine. So tell me now, what's mine to keep when every truth cuts dark and deep? Are we you all knowing anything? Does the blood absolve the suffering? If love's the law, then I am free. But is that law the law of me? Sold. If I am dust, I still am gold. The measure's met, the balance true. No debt remains, save love for you. To owe no man anything, did not the Christ pay everything? The law fulfilled, the veil torn through.